The courtroom battle over Nigeria's presidential election is still unfolding, and one particular argument has captured everyone's attention. At the center of it is a simple but powerful question. Must a presidential candidate secure at least 25% of the vote in Abuja, the federal capital territory, to be declared the winner? In this part of the discussion, we'll slow things down and walk through the argument step by step, breaking the legal language into plain ideas so you can clearly see what the judges are now being asked to decide. To understand the dispute at the center of this petition, you have to begin with a very specific constitutional rule. The petitioners are not just arguing about politics or campaign fairness. Their claim goes straight to the legal conditions that must be satisfied before anyone can officially be declared the president of Nigeria. According to their argument, the declaration of the winner should never have happened because one of those constitutional conditions was not fulfilled. The issue, they say, revolves around Abuja, the federal capital territory. Their case starts with the official election results announced by the Electoral Commission. From those results, they say one fact is not in dispute. The declared winner of the election did not obtain at least 25% of the votes cast in Abuja. And that single detail is where the constitutional argument begins. The petitioners point the tribunal to Section 134, subsection 2b of the 1999 Constitution of the Federal Republic of Nigeria as amended. This section lays out the requirements that must be met for a candidate to be considered duly elected president when more than two candidates contest the election. The rule is actually made up of two parts. First, the candidate must receive the highest number of votes cast in the election nationwide. That condition establishes who leads the overall vote count. But the Constitution does not stop there. It adds another requirement, often described as the geographical spread requirement. According to Section 134, subsection 2b, the candidate must also secure not less than 25% of the votes cast in at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. For the petitioners, that wording is the key to everything. They argue that the Constitution sets these conditions as mandatory steps that must be satisfied before anyone can lawfully be declared president. In their view, the Electoral Commission does not have the authority to overlook or reinterpret those conditions. If the Constitution says they must be met, then they must be met exactly as written. So the question they place before the tribunal becomes very direct. Even if a candidate receives the highest number of votes across the country, can that candidate still be declared president if one of the constitutional spread requirements is missing? Their answer is no. The petitioners say the Constitution clearly requires both the nationwide victory and the specified geographical spread. And according to the official figures they rely on, the declared winner did not obtain 25% of the vote in the federal capital territory. From their perspective, that failure is not just a small technical detail buried in the numbers. It is a constitutional defect. They describe Section 134, subsection 2b as a mandatory provision of the Constitution, meaning it cannot be ignored, relaxed, or treated as optional. If a requirement written in the Constitution is not satisfied, they argue, then the legal basis for declaring a winner simply does not exist. That is why the petitioners frame their case the way they do. They are not merely challenging political outcomes. They are asking the tribunal to decide whether a constitutional condition for becoming president was violated, and if that condition truly required a candidate to secure at least 25% of the vote in Abuja, and that threshold was not reached, then the petitioners say the declaration of the president cannot stand under the Constitution. Once that central question about the 25% threshold is placed before the tribunal, the conversation quickly turns to another part of the Constitution section, 299. This is where the defense builds one of its most important arguments, and it's also where the legal battle becomes much more intricate. The defense points to Section 299 and highlights a phrase that seems straightforward at first glance. The Constitution says that the provisions of the Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. From that single line, the defense develops a powerful claim. If Abuja is to be treated as if it were one of the states, then it should not be treated as something separate or special when calculating the constitutional spread of votes. In other words, Abuja would simply count alongside the 36 states. Following that logic, a presidential candidate would only need to secure at least 25% of the votes in 2/3 of the states overall. Abuja would not stand as an additional requirement on its own. Instead, it would simply be part of the larger group of states considered in the calculation. In practical terms, that interpretation means that if a candidate already meets the 25% threshold in enough states across the country, failing to reach that same percentage in Abuja would not automatically disqualify them. But this is precisely where the petitioners step in and turn the argument on its head. They agree that Section 299 exists, and they acknowledge that the Constitution allows Abuja to be treated as though it were a state in certain contexts, but they insist that the purpose of that provision has been misunderstood. According to their reading, Section 299 was never intended to redefine Abuja as a state for every constitutional purpose. Instead, they argue that the section was created specifically to address administrative matters, how the territory is governed, how laws apply there, and how its institutions function. The petitioners point to the wording of the section itself. It explains that the legislative powers normally exercised by a state's House of Assembly, the executive authority typically held by a state governor, and the judicial authority vested in state courts are in the case of Abuja, exercised by the National Assembly, the President of the Federation, and the courts established for the territory. In other words, Abuja does not have the normal structure of a state government. It has no elected governor and no state legislature. Instead, its administration is handled through federal institutions. For the petitioners, this detail changes everything. They argue that the Constitution only treats Abuja like a state for the limited purpose of governance, so that the territory can function within Nigeria's federal system. That administrative arrangement, they say, was never meant to erase the distinct role Abuja plays in presidential elections. And this is how the debate reaches its core. One side says Abuja should be counted just like any other state. The other insists that its mention in the Constitution serves a different purpose entirely. And somewhere within that disagreement lies the interpretation the judges must now decide. At this point in the argument, the petitioners take a step back from the specific dispute and do something that lawyers often do in constitutional cases. Before arguing about what a particular section means, they first explain how the Constitution itself is supposed to be interpreted. In other words, they ask a more basic question when judges read the Constitution: what rules should guide their interpretation? To answer that, the legal team points the tribunal to a Supreme Court decision delivered in 2022 in the case of the Federal Republic of Nigeria versus Ongajiwa. In that judgment, the Supreme Court restated several long-standing principles that courts rely on when interpreting constitutional provisions. The petitioners carefully walk the tribunal through those principles, almost like laying out a roadmap for how the judges should approach the issue before them. The first principle is straightforward. When the words of the Constitution are clear and unambiguous, the court must apply what is called a literal interpretation. In simple terms, that means the judges should read the words exactly as they appear without trying to stretch them into a different meaning. If the language is clear, the court's job is simply to enforce it. But sometimes constitutional language is not perfectly clear. That brings in the second principle. When a literal reading produces uncertainty or ambiguity, the court should move to a more holistic interpretation. Instead of isolating one sentence, the judges must look at the broader structure of the Constitution to understand how the provision fits into the larger framework. This leads directly to the third rule. The petitioners highlight all sections of the Constitution must be read together. No single provision should be interpreted in a way that makes another part of the Constitution meaningless or redundant. Every section is assumed to have a purpose, and the interpretation should preserve that purpose. The fourth principle goes even deeper. If the wording still leaves room for doubt, the court should consider the intention of the lawmakers who drafted the Constitution. What were they trying to achieve? What problem were they trying to solve? And that connects to the final principle cited in the argument. Judges are allowed to look at the historical context surrounding the law. They may consider how things worked before the constitutional provision was introduced, what gap existed in the old system, and what remedy the new provision was meant to provide. By laying out these interpretation rules, the petitioners are doing something strategic. They are not just arguing what Section 134 means. They are also explaining how the tribunal should approach the entire question of meaning in the first place. Once the rules of interpretation are laid out, the petitioners turn to a detail that might seem almost too small to matter at first glance. Just one word, a single connector sitting quietly in the middle of Section 134, subsection 2BE. That word is "and." According to the legal team, everything hinges on how that word is understood. To make the point clear, they read the provision in full. The Constitution states that a candidate shall be deemed duly elected if he has the highest number of votes cast in the election and has not less than 1/4 of the votes cast in at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. Now here is where their argument begins to sharpen. They say that the word "and" in that sentence is not decorative language. It is not there by accident. In legal interpretation, the word "and" is known as a conjunctive term. That simply means it joins two requirements together so that both must be satisfied. In other words, it does not offer alternatives. The petitioners remind the tribunal that courts have interpreted this word many times before. In fact, they point to earlier legal decisions, including the case of Abubakar versus Yaradua in 2008, where the courts recognize that when the Constitution uses the word, and it is generally meant in its strict conjunctive sense. So what does that mean in practice? It means that the constitutional provision sets two conditions that must both be fulfilled before someone can be declared president. First, the candidate must secure at least 25% of the votes in 2/3 of the states of the Federation. But that is not the end of the requirement. The sentence continues joined by that same word, "and." And that means the candidate must also obtain at least 25% of the votes in the Federal Capital Territory, Abuja. To make this easier to grasp, the explanation turns briefly to a very ordinary example. Think about a simple shopping list. Imagine someone says they went to the market and bought apples, pears, and oranges. Each fruit is its own item. Buying apples does not automatically mean you bought pears, and buying pears does not mean you fulfilled the requirement for oranges. The word "and" simply links separate things that must each exist. That the petitioners argue is exactly how Section 134 should be understood. The states of the Federation form one part of the requirement. Abuja forms another. They are joined by the word "and," which means the Constitution is demanding both. This is why the petitioners describe the conditions as conjunctive and mandatory, not optional, not interchangeable. Both conditions must stand together. And once the argument is framed, that way the conclusion they are pushing becomes clear. If the Constitution requires 25% in 2/3 of the states and 25% in Abuja, then failing to reach that threshold in Abuja means the constitutional conditions have not been completely satisfied, which is why in this entire legal battle, such a small word suddenly carries enormous weight. Because depending on how the tribunal interprets that single, and the outcome of the election itself could be seen in a very different light. As the argument moves deeper into the courtroom, another important layer begins to appear: previous court decisions. In legal battles like this, earlier rulings often play a powerful role, because courts tend to look at how similar questions were handled in the past. These earlier decisions are what lawyers call precedents. In this case, several of those precedents revolve around one familiar question: should the Federal Capital Territory, Abuja, be treated like a state? One of the cases discussed is Okoyode versus the Federal Capital Development Authority, decided in 2005. In that case, the court was asked to interpret Section 299 of the Constitution, the same provision that says the Constitution applies to Abuja, as if it were one of the states of the Federation. At first glance, that ruling appears to support the argument that Abuja can indeed be treated like a state. And that is exactly why it becomes important in the debate. The defense relies on decisions like this to suggest that Abuja should simply be counted alongside the other states when interpreting constitutional requirements. But the petitioners respond by drawing attention to something crucial: the actual question that the court was answering in that earlier case. In Okoyode versus FCDA, the issue before the court was not about presidential elections at all. Instead, the court was deciding whether the Federal Capital Development Authority was an agency of the federal government or an agency connected specifically to the administration of the Federal Capital Territory. The court's discussion about Abuja being treated like a state, the petitioners argue, was tied to administrative structure, how the territory functions as a governmental unit, not how presidential election rules should be interpreted. The same kind of distinction appears in another case cited during the argument, the case of Panya versus the President of the Federal Republic of Nigeria and others. That dispute focused on whether indigenes of the Federal Capital Territory were entitled to representation when ministers were appointed under the constitutional principle of federal character. The court agreed that excluding Abuja from that process would violate constitutional provisions. But again, the petitioners emphasized that the decision was dealing with representation in government appointments, not the conditions required to win a presidential election. And this is where the courtroom strategy becomes clear. The petitioners are not denying that these earlier cases exist. Instead, they argue that a court decision is only an authority for the specific question it was asked to resolve. If a case dealt with administrative powers or representation in government, it cannot automatically determine how election provisions should be interpreted. So, while the defense leans on these precedents to support its interpretation, the petitioners attempt to narrow their relevance. According to them, none of those earlier rulings directly address the relationship between Section 299 and the presidential election requirements in Section 134, which leaves the tribunal facing a question that in many ways still stands on its own. As the petitioners move toward their final reasoning, they return to something that seems simple, but carries enormous weight, the deliberate wording of the 1999 Constitution. In their view, the inclusion of Abuja in the presidential election requirement was not accidental. They remind the tribunal that the earlier 1979 Constitution spoke only about securing 25% of the vote in 2/3 of the states. Abuja was not singled out the way it is today. But when the 1999 Constitution was drafted, the language changed. The Federal Capital Territory was specifically written into the requirement. For the petitioners, that addition must mean something. Constitutions are not written casually. Every word is assumed to serve a purpose. If Abuja is mentioned separately, they argue then the law must be interpreted in a way that gives that mention real effect, not one that quietly cancels it out. Their reasoning also draws attention to the unique position Abuja holds within the country. It is the capital city, the place designed to represent the entire federation. People from every region live there. Different cultures, languages, and communities meet in that one space. Because of that, the petitioners describe Abuja as a national melting pot, a city that reflects the diversity of Nigeria itself. Seen from that perspective, they say the constitutional requirement begins to make sense. If a candidate wants to lead the entire nation, then that candidate's support should reach into the capital where the country symbolically gathers. They then connect this idea to another important detail about how Abuja is governed. Unlike the 36 states, the Federal Capital Territory does not elect a governor. Instead, the president appoints the official who administers the territory and oversees its day-to-day affairs. To the petitioners, this arrangement carries a certain logic. If the president has the authority to appoint the administrator who effectively governs Abuja, then the Constitution could reasonably expect that the president must also earn meaningful electoral support from the people who live there. Put together, they argue these points show that the Abuja requirement was intentional, meaningful, and designed to ensure that the president enjoys legitimacy not only across the states, but in the nation's capital as well. So when you put all the pieces together, the petitioner's position becomes clear. They believe the Constitution sets two separate requirements, winning the necessary spread across the states, and also securing at least 25% of the vote in Abuja. And because that second condition was not met, they argue the declaration of the president should not stand. Now the question moves to the judges. How will they interpret the Constitution? Share your thoughts, and in the next discussion, we'll turn to another major issue, the vice presidential nomination.